Welcome to On the Ballot with Ballotpedia, where we connect people to politics by providing neutral, nonpartisan, and reliable information on our government, how it works, and where it's headed.
Hello, everyone, and welcome to another episode of On the Ballot. I'm your host, Norman Leahy. I'm a senior editor at Ballotpedia. And of course, if you read Ballotpedia regularly, and I know you do, one of the things that we cover are U.S. courts, not only the Supreme Court and federal courts, state courts as well, and the thousands of judges at the state level. But of course, a lot of attention, rightly so, is focused on the Supreme Court. And today, to help us make sense of some of the cases that are upcoming and that have also just been argued and may have decisions coming soon, is Adam Feldman, who's a Supreme Court scholar, law professor, political science professor, author of a fascinating website called Legalytics, and also another thing, the Empirical SCOTUS blog. Adam Feldman, welcome to On the Ballot. Great to have you.
Thanks for having me.
Yeah, Legalytics, new term. Please give me a quick definition of what that is.
It's looking at analytics in the legal framing. So trying to take quantitative data and kind of distill the court through that kind of lens. And so trying to do different kind of measurements and comparisons that aren't always available when you're just looking at legal text. And especially if we're looking at a large number of cases, we can make comparisons across thousands of cases rather than just one or two.
So it's Moneyball for the Supreme Court?
That's a good way of looking at it. Absolutely.
Okay. And it's a great Substack, and we'll put that link down in the show notes too. But let's get to it. It seems like every Supreme Court is monumental in the cases before it, because the cases they address really touch on the basics of our life in so many ways. This current court term is no different. Major cases about citizenship, voting rights, gun rights, executive authority, the things that have yet to be argued, the cases that have yet to be argued in this term. Adam, what's your broad overview of what the court has yet to take up that maybe we should be paying closer attention to?
Well, I think we can talk about that along a few different lines. I mean, they're the obvious ones. The birthright citizenship case is granted. It's not yet set for a date for argument. But that's going to be probably the biggie of this term. It has great consequence. It also follows from the CASA decision, which was previously argued, where some people thought they might take up the issue of birthright citizenship, but the court punted on that and focused on the injunction aspect of that case. So that's the biggie. The other one from the other main kind of large bucket of cases that the court hears, the civil rights and civil liberties cases, is the transgender athletes cases. And that's going to be a big one in terms of defining different rights. And the court seems to have a few different big rights cases each year. And this seems to really be the largest. And then, there's a lot of kind of open terrain. The court has scheduled the arguments in February, but there's still about 13 cases that have not been scheduled for argument. And there are March and April slots. So you have 2 more months of slots. And that means you still have about 7 or so cases that have not been granted yet that will be granted and put on an argument slot. So we don't even know the full breadth of what the court is going to hear by April, and then we'll decide by the end of June, most likely.
And of course, another thing that we're going to be talking about again in this term is presidential power, the extent of presidential power, which has, I guess, in a way become an issue just in the last, what is it? It's not even 24 hours since before we were taping this and this comes out of the Federal Reserve case where a governor sued over the administration's attempt to fire her. I mean, what do you think about that one?
Well, so I think there's kind of a macro issue here and a more of a micro issue. First, the micro issue in terms of different kind of independent agencies and quasi-independent agencies, and then the executive power to remove members. And I think that's I think that there are actually multiple ways of looking at it. So there's a precedent that a lot of people have talked about, the court trying to overturn over the last few years called Humphrey's Executor, and that has to do with removal of members of the executive branch by the president. And so there's a lot of chatter about how the court is most likely going to, at very least, reduce the impact of Humphrey's Executor. And with that, I think that there will be more power for the president to make removals. And it won't, these won't all go to court anymore. But for some of these higher profile positions, especially within the Federal Reserve, I think the court might be a little bit more reticent to give kind of plenary power to the president to make removals. And I think this is kind of part of the narrative of this term, where you have a lot of these cases dealing with executive power, and this is not shocking given Trump's plays to increase the power of the presidency. And so, in past, especially under Trump, the court has been pretty deferential to the moves that Trump's made. But I think we might see some pushback this term, just because of kind of the broad sweep of some of these cases. The tariff case in particular raises this specter of, maybe this is a move where the court isn't just going to wholesale support Trump's position. So yeah, I think that this the executive power questions are one of the primary vehicles that the court's looking at this term, and I think that you'll probably have some moving in both directions, both pro Trump and against Trump, which is very possibly goes against what we've seen the last bit from the court.
Yeah, and those are high level issues too. That I think a lot of people, the average voter on the street, said, "Well, how does this affect me?" So, out of the cases that are out there this term, can you think of one or two that might really hit people where they live? This really does affect
Yeah.
you in your daily life.
Yeah, I mean, the voting rights ones are key. So Louisiana versus Calais was a case that was on the docket last term, was punted and re-argued this term. And uh, the question of redistricting is a big one, both at the state level and then obviously in terms of the litigation at the Supreme Court. But the ability for electors to have say in their representation and where that representation lies is, I think, key across the board. So this is something that has direct effect on just about any voter out there. So when we talk about the kind of lay of the land, I think that's at the heart of it. There are other kind of election disputes. So the Bost case, which was argued in October, is another one that's dealing with candidacy. So it's kind of from the opposite direction. But I think when we're laying down the landscape, really these election and electoral related issues are probably the ones that are going to have the most direct effect on Americans, especially those cases that relate to presidential power.
And as part of the landscape, anytime you talk about the Supreme Court, it is a small set of people, 9 people, and the personal dynamics between that group are either state secrets or they're incredibly fascinating, and sometimes both. Tell us from the data and the analysis that you've done over time, what are the dynamics of this court? Is it more fractious than others that have come before it? Or is there room for common ground? What do the numbers tell you?
Well, one thing we saw in the past, in the recent past, but over 5 years ago, was that there was a clear split between the conservatives on the court and the liberals. That was, it was 4-4 with Kennedy mostly in the middle, and Kennedy on the balance sided with the conservatives most often. And he was a Republican nominee, but was more moderate than many of the others that were on the court at that time. And so there was a clear split. Now the court's under a 6-3 conservative liberal split, and this is it's pretty clear where the justices lie on issues for the most part. But I would say the big change is trying to track when the court is dealing with complicated issues of high ideological salience. and it's not clear that it's going to be a 6-3 split, where that middle is going to be. So it most often falls to, or at least the common narrative right now is it's going to be Roberts, Kavanaugh, or Barrett. There's a kind of the three middle justices. And one of the reasons that that's the discussion point is because those are the three that are in the majority most frequently. And they have been since Barrett joined the court. Each of these three have been in the majority, averaging on about 90% of the time. So they're in the majority when, it's the conservative justices, the other conservative justices, and sometimes some liberal justices are. One thing that's not discussed as much is Gorsuch's role as a swing justice, which is the term that is been used to refer to when you have an ideological split, that you have movement of one or more justices. So there are specific case types like those dealing with kind of Native American rights, where Gorsuch is very oftentimes a swing justice. He moves with the liberal justices, sometimes in the majority, sometimes in the dissent. So I think the big change has been where that middle of the court is and what the meaning of that is. And so while the number of ideological splits has not increased significantly, aside from the 2021 term when Dobbs was decided, the abortion case, part of the interesting question is, are the justices dealing with more ideologically salient cases? And so they're pushing cases that, like Dobbs, that they might not have taken in the past, but where there's a conservative majority that can then push directionally where the conservatives might want to go. So I think that that's part of the dynamic that might have shifted, probably has shifted in the last 5 or so years.
Because I think that's an important point, because the court really does, in a way, create its own weather based on the
Yeah.
cases that it accepts. And in the past, it may not, like you were saying there, it may not have taken some of these issues in the past. But I want to get to something too. It's surprising to me how much unanimity there is on certain types of cases where you can still see those 9-0 rulings. Is that something that we can still expect, or are those becoming more rare over time?
No, I think what's becoming more rare is the number of cases the court takes. Those the total volume has gone down significantly.
Okay.
But in terms of on a percentage basis, the percentage, the rate of unanimity has pretty much maintained at the same level. So anywhere from about a third to half of the cases that court hears on a given term have been and still are decided unanimously. Those are mostly cases that are procedural. They are ones that deal with issues that are they're just cleaner, that the justices deal with, and where there needs to be resolution, but where their preferences, both ideologically and based on interpretation, don't necessarily differ across lines, and so these are tend to be legal questions that resolve more easily. But when it comes to these kind of high friction issues, those are ones we haven't seen come across unanimously in the past, for the most part, and I don't think we're going to see that in the moving forward. But that said, there's always these surprises where there's near or total unanimity. You had Rahimi a couple terms ago. It was one of the Second Amendment cases that a lot of people thought was going to go down along ideological lines, and you had the bulk of the justices share in the majority of not extending Second Amendment rights in that case. And so there are sometimes surprises in cases of high salience, but oftentimes we kind of know where those splits are going to be. If you had to ask me, right now, if the transgender athletes case is going to come down unanimously or along ideological lines, I would say that that's very unlikely to come down unanimously
Yeah.
for a variety of reasons.
Right. And then there's another topic. I was reading through your collection of articles, and one of them that really struck me goes directly to one of the issues that you see a lot in popular commentary today, and that is the Roberts Court's deference to the White House, that it
Mhm.
seems to be an instrument of the White House. And yet you did a bunch of research showing how courts, not only the Roberts Court, but preceding courts, going back, I how far you went back, what, more than 100 years?
Yeah, yeah,
To
around
show
the turn of the 20th century.
how various courts have ruled in regard to cases that affected the executive branch. And the
Right.
Roberts Court was kind of came in a laggard in its deference to the executive branch. And
Right.
can you explain what's going on here?
Yeah. There are a few things. One is the case type dealing with the executive. Those things change over time. So even when we
Sure.
say the executive branch, part of this depends on the type of issues that the executive is pushing. And so when there are cases that have more kind of or they have cleaner constitutional dimensions, then they're easier to answer. And sometimes that'll mean the president's pushing too far, and sometimes that means president is within Article 2 powers. But there's also this question of the shadow docket, and that's become more and more consequential over time, especially under the last several years of the Roberts Court, where you have a lot of these executive branch issues tested initially, and so there are different kind of testing grounds. Another thing that is important to note also is just the way that the court takes cases has changed. The primary vehicle right now is writ of cert, where the Supreme Court has almost full discretionary power over which cases to take. And in the past, mandatory jurisdiction dictated that the court had to take a large percentage of the cases it heard. And so when it takes cases that it chooses to take, that changes the dimensions of deference as well. And so, you have all of these moving parts, but the bottom line is, I think that you have, general acceptance for moves that the executive branch makes that are clearly protected under the Constitution, and then there's usually some other, additional runway given, that's been dictated for cases, across the history of the Supreme Court, going back, going back a long time, but one of the big concurrences by Justice Robert Jackson, talked about the importance of deferring to the president depending on the amount of discretion the president has in a given area. And so, these are old questions. It's not something that's new from the Roberts Court perspective. And and I think when we say executive power, we might be conflating a lot of different types of issues that when maybe in a large sample of cases that starts to normalize, and that's why we see similar numbers. But the expanse of what that really means can create quite a bit of variation.
But you touched on something in there about the shadow docket. And
Yeah.
I'll be honest, I had never heard of this until a few years ago. I didn't know it
Yeah.
existed. I didn't know anything about it, but it has become a big deal for, as you
Yeah.
said, a way that's the court decides cases. How is that affecting court dynamics and really the kind of decisions that we're getting out of the court?
Yeah. So there's been this power that the Supreme Court's had, historically, to take cases on emergency application. Those mainly historically came up in death penalty cases where there
Mhm.
was a need to rule quickly because of the expediency of the matter at hand. And so this isn't a new power, but in the mid 2010s, a law professor at University of Chicago, William Bod, he coined the term shadow docket, which uh, the meaning seems to be more that this happens in the shadows, that it's not something that is done in the public fray, and even more so than other things the Supreme Court does, which are usually pretty guarded to begin with. But at that point forward, there's really been an uptick in this, and this was during COVID, it became a big talking point during more recent elections, where there just needed to be more expediency in a lot of these decisions. But there's been a lot of questions raised about whether the courts, in dealing with these things without oral argument and without full briefing, is really able to make informed decisions on these issues. And so, some of these come to the Supreme Court later on oral argument, but a lot of these are decided on the basis of staying an injunction or upholding an injunction. And that can have, great consequences for some of these issues like hiring and firing, where if the Supreme Court rules on a shadow docket issue and you fire somebody, it's very hard to go back in time and change these things. One other thing that I'll add, and I think it's probably especially important for this audience who is politically savvy beyond just the court, are the political dimensions of the shadow docket, and especially related to the executive. So, what I think is interesting is you have a lot of cases coming from Trump that are coming on the shadow docket, and I think one thing that Trump has found that other presidents might not have been tuned into is that the court had been making a lot of political decisions over the last several decades, and the theory is that due to congressional polarization, the courts had to deal with political issues in a way that it might not have had to in the past. And I think Trump and some of the people that support him in the cabinet probably are tuned into the fact that the court isn't the only institution in the federal government that has the ability to deal with these political issues that Congress was addressing before. And so, it seems like Trump's occasionally just throwing darts on the wall of trying to move the political process forward in the way that Congress might have in the past and the court might have, and taking these issues due to executive action. We can just see the number of executive orders that the president's issued, in 2025 alone, far surpassed previous presidents. And so I think, the president's pulling some of the power that might have been in Congress's and the court's hands in the past and trying to move it through the executive branch. And that's where we see the court at least sometimes scrutinizing some of these moves.
It's fascinating to watch this stuff evolve in real time and to see how it not only changes the dynamics of agencies with the presidents, but the branches with one another. And Adam Feldman, I really appreciate you taking the time to join us today to go through some of these issues. And for our listeners and Google or YouTube viewers, please check out Adam's work on legalytics. It is a great Substack. And if you want to take deeper dives into some of the issues that we've discussed here, please look at the empirical SCOTUS blog, where he talks about some of the things we talked about here. Adam, thank you for joining us on the ballot today.
Appreciate you having me on.
And to the rest of you, of course, you can find this or listen to this wherever you get your podcasts, and you can view us on YouTube. And until next time, I'm Norman Leahy, and we will see you in the digital pages of Ballotpedia. Take care.